Okay, well, good afternoon and welcome to another edition of the Next Level Advisor. Excited again to welcome our guest, Andy Weinhaus. Andy has been on various podcasts and will continue to do so because of the relevancy of what we have been talking about, and that's really what's going on in 2026 on the sunset and the implications of that from estate tax planning. So Andy, welcome. Good to see you again. How are you?
Yeah, good to see you too. Good to see you.
Yeah, good to be with you. And Andy, today I think we're going to take a little bit of a twist, but it's still in the same area. And this is estate planning with business owners. And one of the concerns, questions, or strategies or planning methodologies that many business owners, depending on their structure, type of strategies they look at or planning they do, it stems around buy-sell agreements and also cross-purchase plans, putting in those necessary protections. So I just wanted maybe have you spend a few minutes to talk about what are those type of plans and why are they necessary? And then I've got a couple other questions I want to run with you on that. So why don't we take it from there, Andy?
Sure, Ed, and that's a great segue. So, with a lot of business owners, business succession often falls way to the bottom of the list on things to get done. I understand this, work with a lot of these folks in the state of Missouri. They're running their businesses. They're busy. I understand that very well. But not having a business succession plan can really harm the folks that they love, spouses, kids, whoever it might be, in case, I'll put it this way, something happened, whether it's death, disability, something like that. Maybe off in the future, they just want to walk away and ride off in the sunset. Certainly for an unexpected death, and who expects death, but an unexpected death, having a business succession plan in place preserves what might be a lifetime of work, trying to build up value in a closely held business that might be the most valuable asset they own, maybe more so than their house or retirement plans or any personal assets like a brokerage account or something like that. Oftentimes when I'm working with folks, the closely held business might be, the largest asset in terms of a personal net worth statement that they have.
Mm, mm, mm. So let's, and it's very well said. I think that we think of our business as sometimes being separate and distinct. They're in the rhythm of kind of managing cash flow, growing their business, and really just building a tremendous asset. But it's their business. It's not their asset. It is the culmination of putting those things together. Sometimes from a planning perspective, it's kind of, I don't want to say it's missed, but it's certainly not put in the same context as when you look at assets. So kind of moving into the succession planning, and I mentioned the term buy-sell agreement or cross-purchase. Can you spend a few minutes on talking about what those types of planning strategies are? Those what do they actually represent, and why do business owners consider those things?
Absolutely. So the two major forms that most of us use here in the United States are what we call a redemption, something like that, which is where the business entity, whether it's a corporation, a limited liability company, maybe even a partnership in certain circumstances for state law purposes, is going to be the party that, in a sense, is the buyer of the shareholder's stock. So the entity is going to take back, let's just do a corporation. The entity is going to truly redeem the shares and put them in its treasury as treasury stock. And normally funds are going to flow out of the corporation to, let's say, the deceased shareholder's family, a wife, trust for a wife, husband, trust for a husband, kids, whoever it is. And then, the corporation needs to have the cash to redeem those shares. And this is one of the things that's often missed. We can talk about in a second, hopefully at fair market value. And one of the easiest ways, in a sense, to make sure that cash is available to redeem those shares is the purchase of a life insurance contract when the shareholder or shareholders are young enough, healthy enough, and all the rest to be able to get a policy issued on their life. Cross-purchase, which is the other form, at least in the United States, of buy-sell agreement utilized, is when shareholder A, let's say, holds a policy on shareholder B. Shareholder B holds a policy on shareholder A. They enter into an agreement that at death, Each of them is duty bound, if they're the surviving shareholder, to purchase the deceased shareholder's shares, again, hopefully for fair market value. And that life insurance, again, the policy that shareholder B held on policy A's life and shareholder A held on policy B's life, is oftentimes the main source of cash flow to make sure that that occurs and the widow or widower receives full value from their spouse's lifetime of work for the business. Each of them is very specialized. They have different tax effects. That's very important. I know you mentioned that, Ed, as to what happens when somebody passes away. And you've got to look at each client on a case-by-case basis. I know all the Pinnacle advisors will do that as to which form of buy-sell agreement might work best.
So it's really interesting, as we know that we're in here and actually getting into Q2 of 2024 in short order. We know that there's imminent change. At least many of us believe that to be true. Specifically relates to state taxes and what that may look like coming out of the sunset in 2026. And so you're using the term fair market valuation of sorts. And so if you want to spend a little time on that, the valuation of the business, estate planning, what's the relevancy of that as it relates to the overall size of one estate and how that actually, the application or implications of that?
That's a great question. So for somebody with a very, very large business, and there's plenty of them out there, and it's interesting, whether they understood it or not, or ever had this discussion with their financial advisors, for the business owner, the value of their shares is going to be included in their gross estate for estate tax purposes, getting to either that $13,610,000 amount that we're at right now, or in less than 2 years, maybe only at $6 million or so of fair market value before the estate tax starts to be assessed. So they have to not only be concerned about, what's going on with this business? How am I going to make sure that my wife, my husband, whoever it is, gets the value of that business? But, oh, by the way, I don't want the United States government taking 40% of the value, or even worse, I don't have any way to pay them on that 40% because I don't have any liquidity. And that's extremely important as far as doing that planning, and oftentimes having some life insurance in place that will also allow for the estate tax to be paid if that's needed from a non-taxable source, like an irrevocable life insurance trust. And that irrevocable life insurance trust might also be that party to the buy-sell agreement that purchases the shares for the benefit of the widow, the widower, whoever it is at their passing. That's something that's often missed, Ed. You've got to be careful about not having, if you're lucky enough to have life insurance, you don't want that life insurance subject to estate tax, as well as having the business subject to the estate tax. That's a double whammy, where if they didn't do what we call a cross-purchase buy-sell, and let's say we have only 2 shareholders, each shareholder ended up owning the policy on their own life, that's a no-no, because that's going to include not just the life insurance in their estate for estate tax purposes, it's going to include the value of the business in their estate for estate tax purposes. We always want to do a cross purchase, like I talked about, where B owns the policy on A and A owns the policy on B. So the life insurance, at least, is not in their gross estate for estate tax purposes.
So a lot of moving parts on that, Andy, if I'm hearing you correctly. You've talked about fair market value. You're talking about liquidity. So a lot of times these agreements are put in place. What do you see from a legal perspective is maybe just to do a little deeper dive that is of concern to you with a lot of the agreements that are in place? I'm assuming funding may be one of those, or proper structure. Maybe kind of speak on that for a little bit.
You betcha. So a lot of them, Ed, when I see there is a buy-sell agreement in place from, let's say, a different attorney or somebody other than me, at least in Missouri, and this will be the same across the country. Oftentimes the buy-sell agreement will say that fair market value should be redetermined by the owners every 3 years, every 5 years, and then they don't do it. They just don't do it. So they haven't been keeping up, in a sense, with realizing what the fair market value is that the surviving shareholders need to cover for the deceased shareholders. And if they don't have enough life insurance in place, that more often than not is going to lead to the widow, the widower, the kids taking back an IOU, a promissory note, from either the corporation, if it's a redemption style agreement, or from the surviving shareholders if it's a buy sell that's a cross purchase, and then that family has to wait and hope that that IOU gets paid off to get full fair market value. Now they're at risk, and their, in a sense, blood relative that was part of the business isn't there anymore. They passed away, and they're at risk from people that they may not have known that well, paying off that note to make sure that they get true fair market value if they haven't been doing the updates over the years as to what fair market value should be and how it should be determined.
So, yeah, and I think you're giving a call to action there, but let me just ask you specifically. I mean, what are for the benefit of the audience, what do you see are the needs or the call to action in this regard? It is not just the looming sunset that we're seeing in 2026. You're addressing some key fundamental things that can happen as a result of the actual agreements not properly being funded or created that. So what would you sell to the audience? These are the one or two or three things that specifically that you would recommend that they kind of take action on sooner than later.
Sure. So number one, getting back to fair market value, make sure that fair market value is being determined in a way that truly does, in a sense, capture the value of the business. That might be a appraisal. If, for example, the business is primarily real estate based, if it's real estate appraisers from a qualified appraiser, that might be important. If it's true operating or manufacturing business, they may want to look at something like their then serving CPA, certified public accountant, taking a look at the value of the business from both a revenue perspective, what we call income capitalization, and an asset perspective, what we call book value or something off of book value, and blending those two things, the income capitalization off of something like EBITDA and the asset values, so they come up with a formula that truly does encompass the value of the business. And then, as I just kind of indicated, even if they did that once 5 years ago, 6 years ago, better have a clause in there that they really are duty bound to update that, because what if either the assets went up or the EBITDA has gone up quite a bit and they just haven't been keeping up in terms of having the cash flow available to exit out a shareholder, especially upon somebody passing away.
Excellent. It's helpful. And I guess, Andy, as you very well have spoken to here, needing to put these things in place. And of course, the implications of not putting it in place, just in your last illustration, if in fact the EBITDA has moved up and assets have moved up, the values moved up, and your fair market value was established 5, 6, 7 years ago, kind of running into the estate planning or the estate tax dilemma that's coming up very soon, the implications of that would be huge.
Oh, they are, Ed. They're just huge. The one thing that, in a sense, I would say this, that business owners, if they really thought it through, don't want to end up with is, hey, we're not really getting fair market value right. If I passed away, my widow, my widower, they're not going to see the true value that I might have put a lifetime in building this business. And number two, even if they're doing that right, if they haven't updated, they're looking at probably, even if they had some insurance in place, they might be looking at their family taking back an IOU from fellow shareholders that the widow, the widower, the family didn't really know very well. These aren't all people that necessarily knew each other well in a lot of these businesses. They got together, they had a good concept, they made it grow, but the wives, the husbands, whoever it is, they might not know the fellow shareholders that they'd be counting on to pay off that IOU if they don't have enough insurance in place over what might be a long duration of time.
Yeah. Plus, I think, Andy, there too, I mean, a lot of planning, agreements, reviews, analysis are needing done. And I think one of the things that you may want to close with this is kind of not waiting to the last minute here. It seems like, when would be the good time to start looking at this? Is it now? Is it in a couple of months?
Yesterday.
Oh, yesterday. Okay.
Yeah, so that's a great question, because especially with the closely held business, like I just talked about, with the sunset coming, assuming everybody's insurable, and there's some ways to get around, we don't have enough time on this, there's ways to get around the lack of insurability potentially in some circumstances, but assuming everybody's insurable, assuming that they've got, in a sense, a motivation to get this done, lining up the advisors, especially to cover the estate tax implications, is going to get harder and harder as we move towards the sunset if that becomes a reality, and it very well may. So my mantra this year to everybody that we've spoken to that works with Pinnacle is get it done now. Waiting around, especially if we have a sunset, till the fall of 2025, especially if you've got some indication that something needs to be done with this business, that may not produce a good outcome. Wait until the end is not going to produce a good outcome with what we've got rolling towards us in terms of reduced exemptions and therefore increased estate taxation being at least something that might occur.
Well, listen, Andy, great advice. Certainly a call to action that is there, alerting the audience that do it yesterday, working on this. Again, I want to thank you for your time, as always. We certainly look forward to reconvening again on another topic, but enjoy your time there at Spring Ball, and we look forward to connecting with you soon. Thank you, my friend.
Thanks.